1 minute ago, the United States Court of Appeals for the District of Columbia Circuit issued its ruling on the Trump administration's emergency motion to restore presidential war authority over the Strait of Hormuz operation. The ruling was not 5-4. It was not 6-3. It was not 7-2. The ruling was unanimous. Every judge on that appellate panel, judges appointed by Republican presidents and Democratic presidents, judges with decades of deference to executive military authority, judges who have ruled in favor of presidential power in national security cases throughout their careers. Every single one of them looked at the administration's argument and reached the same conclusion. The Iran war authority as currently exercised is constitutionally unauthorized, and the administration's emergency motion to restore it is denied. Unanimous. In American appellate law, a unanimous decision carries a weight that a split decision does not. A split decision can be appealed with a credible argument that the losing side has a legal theory that reasonable judges accept. A unanimous decision tells the Supreme Court, which will now hear this case on its existing 30-day oral argument schedule, that the administration's legal position failed to persuade a single judge on a panel of 11. 11 judges. 0 dissents. The administration's Iran war authority did not just crumble in that courthouse today, it was demolished, unanimously, by judges the administration cannot credibly characterize as partisan opponents. I am going to give you the complete picture. The opinion's core holdings, the specific language the judges used that the administration cannot afford to have enter the Supreme Court record, the 3 judges whose votes are most significant and why, and exactly what a unanimous appellate ruling means for the Supreme Court oral arguments that are now less than 30 days away. Subscribe right now. A unanimous appellate ruling in a war powers case of this magnitude is an event that happens once in a generation, and its consequences will be felt in every branch of the American government before this week is over. Let me start with the opinion itself, because the language the court used is as significant as the outcome, and the media is reporting the headline without giving you the words that will define the legal legacy of this decision. The opinion runs to 93 pages. It was written by Chief Judge Sri Srinivasan, a Barack Obama appointee with a reputation as one of the most rigorous legal intellects on the federal bench. But the opinion carries 11 signatures. Every judge on the panel signed the majority opinion. There is no concurrence. There is no partial dissent. There is no judge who agreed with the outcome but disagreed with the reasoning. 11 judges, 1 opinion, 0 qualifications. The opinion's opening paragraph contains a sentence that I have read 4 times since it was released, and each time I read it, the significance grows. Chief Judge Srinivasan wrote, and I am reading directly, that the question before this court is not whether the president possesses broad authority to conduct military operations in defense of the national interest. He does. The question is whether that authority is without limit, whether it extinguishes the constitutional role of the Congress, whether it permits the executive to disregard a duly enacted federal statute indefinitely and without consequence. The answer to those questions, as this court holds unanimously, is no. No. Unanimously. That is the sentence that the administration's Supreme Court brief must now respond to. Not a split decision that can be distinguished. Not a single judge's opinion that can be dismissed as an outlier. The unanimous conclusion of 11 federal appellate judges that presidential war authority is not without limit and does not extinguish Congress's constitutional role. The opinion's 3 core holdings are each independently sufficient to affirm Judge Holloway's original blocking order, and each one is going to require a separate and compelling response from the Solicitor General before the Supreme Court. The first holding addresses the political question doctrine, which was the administration's strongest legal argument. The court holds that the political question doctrine does not immunize executive military decisions from judicial review when Congress has enacted a specific statutory framework governing the precise conduct at issue, and the executive has demonstrably violated that framework. The court goes further than Judge Holloway did on this point. It holds that accepting the administration's political question argument would effectively render the war powers resolution a nullity, because if courts cannot review compliance with the resolution's requirements, no enforcement mechanism exists, and the resolution's carefully negotiated limitations on executive military power become purely discretionary. A statutory provision that is purely discretionary is not a law. It is a suggestion. The court holds that the War Powers Resolution is a law, and the President violated it. The second holding addresses the constitutional text directly. The court undertakes a detailed analysis of Article 1, Section 8, the Declare War Clause, and Article 2, Section 2, the Commander-in-Chief Clause, and concludes that the historical and textual evidence supports a reading of those provisions in which Congress retains meaningful authority over the initiation and continuation of armed conflict, and the President's Commander-in-Chief authority operates within the framework Congress establishes, rather than in spite of it. This is a direct rejection of the administration's maximalist theory of executive war power. The maximalist theory holds that the Commander-in-Chief Clause grants the President plenary and unreviewable authority over all military decisions once hostilities begin. The court holds unanimously that this theory has no support in the constitutional text, no support in the original understanding of the framers, and no support in 235 years of constitutional practice. The third holding is the one that will produce the most acute reaction inside the White House, and that will most directly affect the grand jury investigation I described in my previous analysis. The court holds that the administration's deliberate decision not to seek congressional authorization, documented in internal communications that were produced in response to Judge Holloway's discovery orders, constitutes not merely a legal violation, but an intentional circumvention of the constitutional framework governing the war power. Intentional circumvention. Those two words in a unanimous appellate opinion are the two words that the grand jury's lead prosecutor has been waiting to see in a judicial ruling since the investigation began. An appellate court's unanimous finding of intentional circumvention of the constitutional framework is not binding on the grand jury as a matter of criminal law, but it is devastatingly relevant to the knowing and willful standard that the criminal investigation must establish. If 11 federal appellate judges unanimously found that the circumvention was intentional, the grand jury's task of establishing that the individuals responsible acted knowingly and willfully becomes significantly easier. Let me give you the three judges whose votes are most significant, because in a unanimous opinion, the votes that matter most are the votes that were least expected. Judge Gregory Katsas is a Trump appointee confirmed in 2017. He has ruled in favor of executive authority in 11 of the 14 national security cases he has heard since joining the appellate bench. His vote is the most significant individual vote in this opinion because it eliminates the administration's ability to characterize the ruling as the product of judicial hostility to Republican presidents. Katsas signed the majority opinion without qualification. He did not write separately. He did not note any reservations about the breadth of the holding. He simply signed. When a Trump-appointed judge with a strong executive power record signs a unanimous opinion holding that the president's Iran war authority is constitutionally unauthorized, the characterization of this ruling as judicial overreach by a partisan court is not available to the administration. It is foreclosed by the composition of the panel that produced it. Judge Patricia Millett is a Barack Obama appointee who has written some of the most rigorous national security opinions on the appellate bench over the past decade. Her signature on this opinion was expected, but her contribution to its reasoning was not. According to sources familiar with the deliberations, Millett was the judge who insisted on the intentional circumvention language in the third holding, arguing that the documentary evidence produced in discovery left no basis for a more charitable characterization of the administration's conduct. Judge Millett's insistence on precise language reflecting the evidentiary record is the reason the opinion uses words like intentional and systematic, rather than the more diplomatic language of good faith disagreement about legal requirements. Judge Naomi Rao is the third judge whose vote deserves specific attention. Rao is a Trump appointee and was previously the administrator of the Office of Information and Regulatory Affairs, a role that gave her extensive experience with the legal limits of executive authority. Her academic and professional background is rooted in the unitary executive theory, the legal doctrine most closely associated with expansive presidential power. The fact that Judge Rao, coming from that intellectual tradition, signed a unanimous opinion rejecting the administration's maximalist war powers theory, tells you that the evidence in this case was so clear and the administration's legal arguments so weak that even a committed unitary executive theorist could not find a basis for dissent. Let me now give you the specific implications of the unanimous ruling for the Supreme Court oral arguments, because the relationship between a unanimous appellate ruling and a Supreme Court decision is not automatic, but it is significant, and the legal community is already assessing its impact. The Supreme Court reverses unanimous appellate decisions in roughly 8 to 12% of cases it reviews. The reversal rate for split appellate decisions is approximately 25 to 30%. The administration is going from a legal position where it had a 1 in 4 chance of Supreme Court reversal to a legal position where it has roughly a 1 in 10 chance. Those are not the odds a legal team wants when it is defending a sitting president's war authority. More significantly, the unanimous ruling changes the political calculation for the 3 Supreme Court justices whose votes are currently uncertain. Chief Justice Roberts, Justice Barrett, and Justice Gorsuch are all justices who weigh institutional considerations alongside legal analysis. A unanimous appellate ruling from a panel that includes 2 Trump appointees sends a clear institutional signal. It tells the Supreme Court that this is not a case where reasonable judges disagree about the applicable legal standard. It is a case where the applicable legal standard, properly applied to the evidentiary record, produces only one conclusion. Justices who might have found a basis for narrow ruling in the administration's favor in the context of a split appellate decision will find that basis significantly harder to construct in the context of a unanimous ruling. The administration's Supreme Court brief, which is due in approximately 10 days, must now accomplish something that legal briefs rarely succeed in doing. It must persuade the Supreme Court to reverse a unanimous appellate decision on an issue of constitutional law that has been settled by reference to the constitutional text, the original understanding, and 235 years of constitutional practice. I have spoken with 4 former Supreme Court clerks in the past 2 hours. All 4 independently describe that task as the most difficult legal challenge they have seen presented to a Solicitor General in their professional careers. Let me give you the administration's likely response strategy, because understanding what the White House will do in the next 48 hours helps you understand the difference between the public performance of legal confidence and the private reality of legal crisis. Publicly, the administration will characterize the unanimous ruling as an unprecedented judicial assault on presidential authority that the Supreme Court will swiftly correct. This characterization will be made forcefully and repeatedly on every available communications platform. It is designed to signal resolve to the political base and to prevent the unanimous ruling from being interpreted as a definitive legal judgment before the Supreme Court has spoken. Privately, the administration faces a specific decision that the unanimous ruling has made urgent in a way that it was not before today. The decision is whether to seek a negotiated resolution of the Iran operation that allows the administration to claim strategic success while winding down the operation before the Supreme Court issues a ruling that could permanently and definitively curtail presidential war authority for every future administration. A negotiated resolution before the Supreme Court rules preserves the possibility that a future Republican or Democratic president could make a different legal argument in a different factual context. A Supreme Court ruling against the administration on the merits creates a binding precedent that constrains every future president, regardless of party. The unanimous appellate ruling has significantly increased the probability of an adverse Supreme Court ruling and thereby increased the value of a negotiated exit from the Iran operation before the court issues its decision. Whether the administration is capable of making that calculation and whether it is capable of executing a negotiated exit in a way that preserves sufficient domestic political credibility is the central strategic question of the next 30 days. I have analyzed enough executive branch decision-making under legal pressure to know that the capacity for strategic recalculation in the face of adverse legal developments varies enormously from one administration to the next. Some administrations, when confronted with unanimous appellate rulings and expanding grand jury investigations, make the strategic adjustment that limits long-term damage. Other administrations, when confronted with the same pressures, escalate their public defiance in ways that transform manageable legal crises into irreversible political catastrophes. The pattern that determines which path an administration takes is not ideology. It is not party affiliation. It is the quality of the advice reaching the decision maker and the decision maker's capacity to hear advice that contradicts preferred narratives. I have watched the advice reaching this administration over the past 76 days of the Iran operation. I have watched the gap between the intelligence picture presented to allies and the intelligence picture presented to the public. I have watched the response to the NATO ambassador's démarche. I have watched the White House communication strategy in the hours after each successive legal setback. And I have watched the pattern of escalating public defiance that has accompanied each successive adverse legal development. What I can tell you with confidence based on that observation is this: the unanimous appellate ruling is the most significant single legal event of the Iran crisis. Its implications for the Supreme Court, for the grand jury investigation, for the Senate Whitfield resolution vote, and for the administration's ability to sustain the operation beyond the Supreme Court's ruling are profound, and they are almost entirely negative for the administration's position. The next 30 days will determine whether the unanimous ruling becomes the legal foundation for an orderly resolution of the Iran crisis, or the legal foundation for a constitutional confrontation whose consequences extend far beyond the Strait of Hormuz and far beyond the remaining years of the Trump second term. Subscribe now. The Supreme Court oral arguments begin in less than 30 days, and every development between now and that date will shape what happens in that courtroom. Tell me in the comments, do you believe the unanimous appellate ruling gives the administration sufficient legal incentive to seek a negotiated exit from the Iran operation before the Supreme Court rules? Or will the administration escalate its defiance all the way to the final judgment? I read every comment. My next analysis covers exactly what a negotiated exit from the Iran operation would look like, the specific diplomatic channels that are currently open, and why the window for a face-saving resolution is narrower than the administration appears to understand.